Section chair. Sorry, I'll start again. Hi, this is Scott Zucker. I'm the section chair for ADR for the Georgia Bar, and very excited to invite all of you to join us today to hear from folks with the Carter Center on issues of dispute resolution from an international point of view. I have to give you a little bit of a backstory about how this all came to happen, and I'll turn it over to our presenters. Recently had the opportunity to go back over to the Carter Center Library, and just I'm sure many of you have been there, but visiting the library and walking through the halls and understanding that one of the number one sort of goals of the Carter Center as part of its moniker is resolving conflicts, and we of course know that from its years of working on peace treaties around the world. But there was in particular a quote from President Carter that's on the wall of the library. And for all of us who are mediators and neutrals and work and believe in the concept of ADR, these words really meant something to me, and I'm sure to many of you. The expression, "We fought fire with fire, never thinking that fire is better quenched with water." And that really struck with me, and I know that sort of defines the mission of the folks at the Carter Center with regard to dispute resolution and efforts towards peace. So on behalf of our section, I reached out to the Carter Center, and now I've worked with all these fine people that I'm about to introduce you to have them agree to do a program for us today on conflict resolution, again, from their experience internationally, and hopefully, and I'm really confident, will apply to all of us with our work in ADR here locally. So let me first introduce the group. Some are just joining us by phone, so others will see. First with Victoria Ayer. She's a director at the Carter Center with over 2 decades of international development experience. Victoria has led anti-corruption consortia, incubated innovative approaches, and supported reformers working to improve accountability in countries in conflict and in transition in the Balkans, Southeast Asia, and Africa. She's worked as an anti-corruption advisor in the U.S. Agency for International Development, mobilizing data for anti-corruption, along with governments, tech entrepreneurs, academics, and civil activists. She received her JD degree from BU and a Bachelor of Arts in Political Science from Rice University. So that's Victoria. And again, let me tell you, these bios are shortened just for time purposes. These folks have incredible resumes. Next, I want to introduce Hillary Forden, a Senior Associate Director with the Carter Center. Hillary also is a lawyer and a development practitioner with more than 15 years of experience in rule of law development, post-conflict justice, and criminal law, including over 10 years of experience managing multi-billion-dollar programs for the U.S. government, public international organizations, and non-governmental organizations. Prior to joining the Carter Center, Hillary consulted with the Department of State and other funded programs on anti-corruption and legal education projects. She has previously managed rule of law development projects for the International Development Law Organization in South Sudan and the United Nations Development Program in Sudan. She holds her JD from Yale and a Bachelor of Arts from University of California, Berkeley. Third is Nick Rogers, a Senior Program Associate with the Carter Center, working with their Rule of Law program. He provides support in the program's various international projects with a primary focus on those in Liberia. First joined the Carter Center in 2017 as an intern in the Conflict Resolution Program, and then joined the Rule of Law program in 2018. He received his bachelor's degree in international affairs from the University of Georgia. And then finally, all the way from Liberia, is Joshua Pelawa, who currently serves as project lead for the Carter Center's Rule of Law program in Liberia, where he has coordinated up to 4 access to justice projects simultaneously. Seasoned professional, Joshua is currently earning his law degree at Lewis Grimes School of Law in Monrovia, Liberia. So it's my pleasure to introduce the 4 of them today to speak to us about conflict resolution and ADR in these international situations. So I'll turn it over to you.
Thanks, Scott, for the introductions, and we will just jump right in here from the start. Apologies to everyone that's in attendance today. I'm having some technical challenges, so don't have a working camera, but we're just going to go with the flow. As Scott mentioned, today's presentation will be on ADR and national reconciliation and rebuilding CLE, and we'll be specifically focusing on those experiences from Liberia, Rwanda, and the Gambia. So Hillary, if you could jump to the Liberia slides, that would be great. Wonderful, thank you. All right, so to start things off, I want to quickly set the historical stage for our access to justice programming in Liberia. And following a coup in 1989, the country fell into a brutal civil war that claimed the lives of an estimated 200,000 citizens of its 2.5 million population. And that war went on until 2003, when a comprehensive peace agreement saw the exile of then President Charles Taylor and the establishment of a transitional government. And then in 2005, Liberians elected Ellen Johnson Sirleaf as their president. And that's a name many of you might be familiar with. And with the help of the United Nations peacekeeping forces and others in the international community, Liberia began to rebuild. And at the end of the war, the justice system in Liberia was really in terrible shape, and its credibility was really non existent. There was a lack of human, material, and financial resources that severely hampered the administration and delivery of justice in the country. So, a critical element of Liberia's long term reconstruction has been to reestablish the rule of law and really try to rebuild that trust in government. Next slide, please. So now some of the key issues in post-conflict Liberia are highlighted on this slide. I won't go into all of them, but we'll point out a few that our programming worked to address. The first being widespread trial by ordeal. So trial by ordeal and ritual killings persisted in great numbers following the Civil War. And in such trials, people accused of crimes are subjected to ordeals. So that could be swallowing a poisonous drink or enduring burning or pain to determine their guilt or innocence. And these practices were really prevalent in rural areas where police, military, and legal authorities were mistrusted because of rights abuses during the war. Another issue that's led to frequent conflict in Liberia revolves around land disputes arising from changes in boundaries and property lines. And this has really long been a serious problem in Liberia, given that a majority of government held land deeds and records were burned, stolen, or lost during the Civil War. One of the most serious problems in Liberia, both during the war and post conflict, was rape and sexual violence. And given the weak criminal justice system and high levels of police and judicial corruption, families and community leaders have often intervened to resolve those cases of sexual violence through traditional means, rather than taking them to the proper authorities because they didn't have trust in those systems. And finally, there's the simple fact that citizens are unaware of their rights and responsibilities under the law, that being one of the primary issues that our programming has worked to address. Next slide, please. So now we can move into the actual work of the Carter Center. So in 2006, at the invitation of the government, the Carter Center began implementation of the Access to Justice project to help address those critical issues that we highlighted in those previous slides. So this primarily focused on those historically marginalized populations in rural communities around Liberia. And in the immediate aftermath of the war, the project partnered with the Ministry of Justice to identify rural justice needs and develop and implement civic education messages and fill immediate short-term gaps to strengthen the formal justice system. And as these civic educators worked in those rural communities, citizens kept coming to them to ask to resolve cases that they were having. And this really led to the development of the Community Justice Advisors programming, in partnership first with a civil society organization known as the Catholic Justice and Peace Commission, that later evolved into partnerships with 6 civil society organizations spread across the country. And with technical support and funding through the Carter Center, these CJAs have provided civic education, voluntary mediation, and case-specific information to citizens in 8 of Liberia's 15 counties. And they've worked to accompany clients through legal processes and also monitored the courts, prisons, and local policy issues in their communities. And they've also worked to forge relationships with magistrates, police, and traditional leaders to help ensure that justice issues are handled by the appropriate authorities. Next slide. So this slide highlights some of the engagement strategies that our CJAs have undertaken over the years. One of those primary strategies has been through the development of community radio dramas, jingles, and talk shows in local languages about issues such as, let's say, criminal procedure, land ownership, the revised rape law, women's inheritance and property issues, and really a primary focus on the roles and responsibilities of different local justice actors within the community. But the real crux of our CJA programming has centered around direct community engagement. So the CJAs are all assigned specific communities within their counties of operation, and they host regular community-based civic education sessions, town hall meetings, law and justice events at many of the schools in the communities, and even some have gone through a door-to-door approach. And one of the most important notes, I would say, is that CJAs are all non-lawyers, actually. They work within these civil society organizations that we provide sub-grants to carry out this work. And then they're mentored, trained, and supported by the Carter Center's county-based project officers and legal associates, all of whom are lawyers. And in a few moments, my colleague Josh will take a deeper dive into the successes and impact of this work. Next slide, please. So next, I'll move to the second primary focus of our Access to Justice project, being our work with traditional leaders in the country. So Liberia has a dual justice system that involves both a formal court hierarchy under the judiciary and a system of customary courts that's led by Liberia's traditional leadership, being the chiefs within the communities. And at the local level, much of Liberia is under the authority of customary leadership, and that's the law that's respected and noticed. So chiefs are employed to administer towns, and really this kind of includes resolving low-level civil disputes, having a primary say in allocating communal land, as well as overseeing all social and cultural aspects of the community. And again, Liberia is a unique context in that these chiefs are an important element of everyday justice that's actually recognized by the formal government. And in 2010, in response to requests from the government once again, the Carter Center began a new effort aimed at strengthening traditional leaders' conflict management capacity and alternative dispute resolution skills. Next slide. So the pilot project focused on building the nonviolent dispute resolution skills of traditional authorities, youth leaders, and women leaders in our target counties. And this programming provided training that focused kind of solely on the rule of law, dispute resolution techniques, and inclusive governance. And the Carter Center worked with these community leaders outside of those trainings to also provide support for national and local dispute resolution efforts and to convene town hall meetings for further trainings at lower levels for the various levels of the chieftaincy structure in the country. So while doing this, the Carter Center also always tried to invite the participation of local justice officials to these sessions to try to build an understanding between the community and the formal authorities, really trying to bridge that gap between the formal and traditional structures in the country that had grown so wide during the Civil War. And since its launch, the project has trained chiefs at all levels in the target counties, and the impact has really been significant, both in terms of increasing the chief's ability to take ownership of local conflict and in changing their practices and attitudes about the law and the roles of women and youth in the community. And with that, I will hand it over to my colleague Josh for a look into the data and impact of the programming that I've just gone through. Over to you, Josh.
Thank you, Nick, for laying down that foundation. So now I'm going to be talking about data. I'm going to be providing this discussion over twofold. Earlier, you heard Nick talking about the non-lawyers, which are the community justice advisors. They've been doing a lot of work directly with citizens, with the formal and the customer. And then later, I will be presenting the section of the data that was collected by our county dispute resolution monitors over the period. And we are talking about data since 2007 to today's year of 2023. Next slide, please. So our non-lawyers, which are the community justice advisors, have been able to document over 31,000 cases that they recorded. And these community justice advisors, on the average, we had close to a little over 55 of the community justice advisors that lived in the communities. So each community justice advisors was assigned to 10 communities across the 8 target counties that we work in. So they had to spend their time, they had to do a lot of civic education, they had to get adjusted to knowing the terrain and understanding how to engage these citizens. And based upon this civic education, the citizens then decided to bring cases directly to them. Now, if you look at the slide, it's interesting to note that because of the level of trust these citizens had in these community justice advisors, a little over 51% of these citizens directly brought cases to the community justice advisors. Also looking at the slide, you notice that cases that were to some extent handled by our customer mechanisms, that is the traditional leaders, which are the chiefs, women and youth leaders. They also involve our community justice advisors, which made up to a little over 31% of the total cases that were documented during the period. The formal justice mechanism, that is cases that were brought out of the magistrates or the police or during visits that these community justice advisors made to the prison. You also know that a little over 14% of those cases were brought to our CJAs for either mediation or arbitration. Now, the top 5 cases over the period, the first stop was, child support, followed by the issue of property and land dispute, and then debt and the bottom 2. It's interesting to know that the issue of child support is very persistent in the counties where we've worked, and these were cases that happened over the time period, and our CJAs provided a lot of support. Also, it's important to note that we have data collection tools that the CJAs use over the period to ensure that this documentation was done properly over time. And sometimes it takes several days or weeks for the CJAs to be able to record, document, and then be able to record these cases. Now, the chart just shows you that in terms of, next slide, please. Larry, next slide, please. Yeah. In terms of the child support cases that made up almost 1 in every 5 cases. So this is very high. This was very high over the period. And this is quite alarming, but again, people needed redress, especially issue of persistent non-support. These were cases that you're seeing going to either the customer leaders or to the former justice system. And our community justice advisors were very, very important in ensuring that they provided this level of support. And it's also interesting to know that the issue of debt was also high. People having issues, and this is something that in the past would create a very heightened violence in communities. People will fight, or there will be violence. But since the involvement of our community justice advisors, they knew that, hey, okay, fine. If we have the issue of debt, instead of having some clash, it's better we have to just go to non-lawyers that can help us resolve our cases without any costs. The Carter Center bear all of the costs or charges in handling these disputes. So it's very important to also notice this. Property land dispute is very huge in Liberia, especially in 2 counties of Nimba and Lofa counties. And this is something that could create serious chaos among other families or citizens, among communities. And our CJAs, with their experience, they were able to mediate in settling land disputes. It could be out of boundary, or it could be farmland or community land, or maybe a house spot. They were very instrumental in documenting and helping to resolve these cases. Next slide, please. Now, how do we define a successful outcome as far as our mediation is concerned? And in order to look at an outcome as being successful, we have to say, okay, fine. Was there a mediated agreement that came out as a result of the mediation that was done by the community justice advisor, or was there a payment plan in how the debt should be settled, or whatever compensation should be given because of whatever issue, or probably someone was detained wrongfully and they were released for detention. So given the level of work and the level of engagement our community justice advisor did, it's interesting to know that the success rate post cases that came from the formal justice system, it was at 36.85%. That is 1 in every 3 cases that came to the community justice advisors from the former justice system were successfully mediated by our community justice advisors. And again, these are non-lawyers that we provided training, that we provided the skills, and have been doing this kind of job without even learning anything at law school. Also, the issue of wrongful detention or arbitrary arrest was an area that our community justice advisors did extremely well in resolving. And if you look at the level of percentage, it's 81.93%, which is very, very huge. But again, it requires a lot of work, a lot of documentation, and actually knowing what the rights are for citizens in terms of what is wrongful detention or arbitrary arrest. And then they're going into the system, going to the formal justice system, and they're telling the police, hey, you can't hold this person here. I mean, this is wrong. You have to help to see how best you can get him out. So that's another important area that our program score a huge mark. Also concerning the issue of theft and child support, there's also a huge success rate in our CJAs mediating because, for example, theft, we had in terms of the total cases, almost close to 47% of the cases involving theft were successfully mediated by our CJs, and then child support, which makes up, the top of the top five. They were able to handle, a little over 40% of those cases were successfully mediated without having to go to court or without having to be further detention or other problematic issues that our community justice advisors were able to successfully resolve. Next slide, please. We'll move to the second phase of our ADR work, which has to do with our county dispute resolution monitor. These were staff of the Carter Center, eight of them that work directly with the chief. Now, Nick said earlier that in Liberia we have a dual justice system. We have statutory and customary. So this work focused more on the customary actors, the chiefs, the women leaders, the youth leaders. And again, these are people that are respected in the communities. Usually when there are cases or there are problems, these are the go-to people. So regardless of there being the presence of police or courts in these communities, these chiefs are highly regarded and people take a lot of disputes to them. So over the period, our CDRMs were able to record over 5,753 cases were recorded. And I will be taking you through some of these cases that were documented by working with these traditional chiefs, women, and youth leaders. Next slide. So again, what's the most common disputes that came directly to the chief? You will notice that the issue of property and land was very high, and that of debt. And land is a very big issue here in Liberia, and people don't joke with it. So it's something that lives could be lost if not handled properly. There could be chaos. There could be a lot of in-house fighting, and it's because people get property. They don't go through the rightful title. So it's the issue of maybe it's passing out of them from your forefathers, or somebody is buying it, but they are not educated as to how to complete the process of registration, probating your deed, and following all of the rightful parameters that is required by law. So again, this is a very serious issue that have come to the chiefs, and our staff were able to work with these chiefs in seeing how best they could document these cases and how mediation could be done. And to some extent, where the chiefs could not handle these disputes, our county dispute resolution monitors work with them to say, okay, fine, let us accompany you and work it through the formal justice system, because again, that is why we have the courts. That's why we have the police. If these issues cannot be resolved amicably at the community level, then it's better we file these cases again to probably the police or get the courts involved. So every step of the way, our CDRMs work with these traditional leaders to ensure that these disputes that were coming to them were handled. Like I said, they are the go-to people, and people respect their views, people respect their leaders. And even if there are cases that have some criminal connection, the citizens still felt that they needed to go to the customer before going to the formal. But again, over the period, we made it clear to the chief, like, look, any criminal matter should not be handled by customary leaders. All criminal matters must be handled by the formal justice system. You can only look at civil matters. And again, if you are asked to give your opinion or advice, it has to be done properly and with the right guidance. So again, these are the top cases that the top 5 most common cases that came to these chiefs during the period. Next slide, please. So what are the outcomes of the disputes in terms of how they were mediated? So the first step in terms of our mediation the process of resolving this dispute first is mediation. And again, it works so well for us. And the citizens, the chiefs, even those former justice actors were very, very happy by the level of knowledge that either the chiefs had or the CRMs had in ensuring that these disputes were resolved, because mediation is key. And again, we just played the role of supporting, but again, the parties were the one who were really involved in driving the mediation and in ensuring that they had a level of success. So you find that issue of debt, for example, which was very high in having successful mediation followed by property land dispute, which is landmark, because before the center came in, most of these cases were going to courts. People were taking cases to the courts, and you notice that the court dockets were so full that most of these cases kept stalling, and there were no redress, and that led to a lot of fighting at the community level because people were tired. And again, people didn't trust the justice system because they said, okay, look, we have our cases that have stayed here forever, and we can't just get redress. So that it was very chaotic before the Carter Center came in. But when we came in with our line of work, this ADR and mediation really helped, and people really trusted the process. And it's seen from the data and from the results that we collected over a decade of work in Liberia. And this is so meaningful, and that's the reason why even the government of Liberia respect the work. They see us as a direct partner, and usually when there are issues of disputes, especially boundary dispute or community disputes, the Carter Center is to go to international organization to be able to help in resolving these matters that have transpired over the period. So in a nutshell, this is the level of work. We have huge data across all of the counties where we've worked, and we're happy to delve in more. But this is basically what we have to show in terms of our level of work over a decade. Thank you.
Hi, thank you, Josh, and apologies all, I have to unmute and reshare in order to, I couldn't figure out. So apologies in advance for anything strange, or I guess for anything strange you saw on your screen while I was trying to figure out how to manage Zoom while presenting slides. I'm now unmuted and I will reshare my screen. All right, hope everyone can hear me. So my name is Hillary Forden, and I'm going to speak a little bit about transitional justice more broadly, with some specific examples from Rwanda and the Gambia. And the Gambia is a country where we have recently started working on a transitional justice project through the Carter Center. Oops. So what you'll see on your screen now is the United Nations definition of transitional justice. Transitional justice is an umbrella term that is used to describe the full range of judicial and non-judicial processes and mechanisms that societies adopt in an attempt to come to terms with large-scale past abuses such as civil wars, genocide, crimes against humanity, or wide-scale human rights violations. And these can range from accountability mechanisms to reconciliation to reparations for victims, to processes to actually just reform society and the rule of law, justice system, and including elections. There are several goals of transitional justice, which, as you can see, can include truth-telling or memorialization of what happened, reconciliation within society, accountability, reparations for victims, and institutional reform. And there are several mechanisms through which transitional justice may happen, different approaches that different countries and societies have used over time. One, for example, is a Truth, Reconciliation, and perhaps Reparations Commission or Truth and Reconciliation Commission. The first of these were implemented in Latin America in the 1980s and 90s in an effort to unearth the truth of human rights violations committed under the military regimes in that part of the world, with some of the first being in countries such as Argentina, Guatemala, Chile, etc. Another type of transitional justice mechanism is reparation schemes. And one example of this was a United Nations Compensation Commission that was set up after the first Gulf War to compensate Kuwaitis who had had either material or human rights losses as a result of Iraq's unlawful invasion and occupation of Kuwait. Then we have international and hybrid criminal tribunals, and one of these that you likely will have heard of is the International Criminal Tribunal in the or International Criminal Court, not International Criminal Tribunal, International Criminal Court in The Hague, which was set up through the Rome Statute, which is a treaty. Then we have the ad hoc international criminal tribunals, and a couple of examples of these would be the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, which were both established through United Nations Security Council resolutions. And then there are hybrid courts or tribunals, and this is a mix between a domestic tribunal or domestic court and an international court. And they, a few examples of those are the Special Court for Sierra Leone and the Extraordinary Chambers for the Courts of Cambodia. And these were set up through different mechanisms, but they are joint initiatives of the United Nations and the local national governments and justice systems. And so they include staff and lawyers, judges, prosecutors from the local jurisdiction, as well as internationals who are United Nations employees. And then we have international arbitration mechanisms like civil arbitration. So a few examples of these are commissions that were set up under the Permanent Court of Arbitration, which is based in The Hague. And a couple examples are the Eritrea-Ethiopia Claims Commission and Eritrea-Ethiopia Boundary Commission, were set up as part of the peace agreement between Eritrea and Ethiopia at the end of their 1998 to 2000 border war. Or in another case, we have the ABA Boundary Commission and the ABA Arbitration Tribunal, which again were kind of overseen or administered by the Permanent Court of Arbitration. And these were set up to resolve the boundaries of the kind of area of ABA, which is part of Sudan, as part of the 2005 peace agreement ending the civil war in Sudan that ultimately led to the division of Sudan and South Sudan into two separate countries. And ABA was one of these border areas. And so this commission was set up to decide what the boundaries of ABA should be. Then we have domestic criminal prosecutions, and these can be in the domestic statutory courts, whether this is a common law legal system, civil law system, etc., for crimes committed during a moment, human rights violations, crimes against humanity, war crimes, etc., in domestic courts. And then we also have prosecutions through customary courts, and I'll get into that a little bit later as I talk about the gacaca in Rwanda. Then we have memorial schemes, and this may be setting up museums or national monuments to commemorate those who lost their lives or were otherwise, harmed by a national tragedy, a civil war, a genocide, etc. And they can also include days, national commemoration days, or maybe special curricula in the schools to teach the legacy of past abuses. And then the last one I'm going to highlight here are vetting processes. And this is a mechanism sometimes conducted completely by a national government, sometimes with international assistance, to vet individuals to determine whether someone has participated in past abuses and perhaps bar them from serving in the government, and in particular maybe in positions of trust such as with the police, with the military, or with the judiciary. Now, I want to focus a little bit here on Truth and Reconciliation Commissions. A Truth Commission or a Truth and Reconciliation Commission, also known as a Truth and Justice Commission, is an official non-judicial body that's established either by a country or by a country with international assistance, and tasked with discovering and revealing past wrongdoing by a government or non-state actors in the hope of resolving conflict left over from the past. Truth and Reconciliation Commissions are victim focused and victim centric, and they tend to finish their work with a report documenting their findings from the testimony of those who spoke at the commission, and recommendations for the future. And those recommendations can range from recommendations for amnesty for particular individuals who might have been involved in wrongdoing, to recommendations for accountability of prosecutions, to recommendations for example, memorialization or barring particular people from holding government offices, etc. And what you will see on your screen are a non-exhaustive list of countries that have had Truth and Reconciliation Commissions in the past in response to past abuses. But one that I wanted to focus on a little bit is that in South Africa, which is one of the best known internationally. And the South African Truth and Reconciliation Commission was set up by the Government of National Unity to help deal with what happened under apartheid. And the conflict during this period resulted in violence and human rights abuses from all sides, and no section of society escaped these abuses. So under the Promotion of National Unity and Reconciliation Act in South Africa, they established the Truth and Reconciliation Commission. And according to the former Minister of Justice, Dula Omar, this commission was necessary exercise to enable South Africans to come to terms with their past on a morally accepted basis and to advance the cause of reconciliation. And what you see here is a visual to raise public awareness about the TRC in South Africa. Oops. And now I'm going to focus a little bit on transitional justice in Rwanda. Now, in Rwanda, they did not have a Truth and Reconciliation Commission following their 1994 genocide. Rather, all of the primary transitional justice mechanisms that were established to address the many abuses committed during the genocide were punitive in nature or included accountability and punishment for criminal wrongdoing. And so those include the United Nations International Criminal Tribunal for Rwanda, which was established by the UN Security Council shortly after the end of the genocide in 1994. And what you see on your screen is a courtroom and a trial at the ICTR. Now, I used to work at the ICTR from 2009 to end of 2010 in the chamber support section. And so in the front of the screen, you'll see the judges, and I used to work with the judges in kind of a position equivalent to a law clerk in the United States. And the UN ICTR was set up primarily to investigate. It's a standalone tribunal set up to investigate, prosecute, and adjudicate cases involving those who were considered most responsible for the genocide. So those who planned it, orchestrated it, and led the genocide. Then Rwanda had planned to prosecute the remainder of potential suspects of the defendants in their domestic criminal courts, and they started that process, but they experienced a severe backlog, and as a result, they were significantly behind in around 2001. And so at that time, the country decided to embark on a rather innovative and ambitious campaign to basically redirect a number of the lower level criminal cases or involving those suspected of participating in the genocide to something they called gacaca courts. So the gacaca courts derive from a traditional form of dispute resolution in Rwanda that honestly, it existed before colonization in Rwanda, but it actually largely fallen into disuse before the 2001 when the gacaca courts were established around Rwanda to provide accountability for those responsible for participating in the genocide. And the gacaca originally stems from a Kinyarwanda word for short grass, referring to a public space where neighborhood elders would meet to resolve local problems. And they primarily, originally in pre-colonial times, they focused on resolving disputes between families or within communities. They'd not previously been used to address wide-scale abuses such as a genocide. But in this case, these new gacaca courts were established at the community level throughout Rwanda to speed up the prosecutions of those who were awaiting trial for genocide. So over the course from 2002 to 2012, over 12,000 gacacas operated in communities throughout Rwanda. And over those 10 years, they handled nearly 2 million cases in 4 different categories of severity. And they were basically the judges and the lawyers, the quote unquote lawyers who served in these courts were members of the community. They did not necessarily have prior legal training. And they resolved the cases in communities like this. This is a picture of a gacaca operating in a community in Rwanda. And they had kind of mixed, sorry, let me just quickly say this, that there were more than 160,000 judges who were elected from their communities to serve in the gacacas. But as I said, they lacked legal qualifications, and local and international human rights groups have expressed concern about the fairness of these trials because they were held without defendants having access to qualified lawyers or other basic what we consider fair trial rights, including there was no right to a lawyer, no right to be presumed innocent until proven guilty, no right to be informed of the charges being brought against the accused, no right to defense preparation time or the right to be present at one's own trial, nor right to confront witnesses, right against self-incrimination, no right to against double jeopardy, and no right against arbitrary arrest and detention. That said, so there were a lot of criticisms both from Rwandans as well as international and regional human rights experts on these grounds. At the same time, other Rwandans said that that the Gachachas helped families find murdered relatives' bodies so that they could bury them with dignity. They also ensured that tens and thousands of Rwandan perpetrators were brought to justice. Some Rwandans say that they set in motion reconciliation within their communities. And many praised the Gachacha as as helping to mend the wounds of the past in that country. The majority of compliments or sort of the majority of praise for the Gachacha has come from the Rwandan government and Rwandan citizens, whereas the majority of concerns have come either from the outside or from Rwandans who were, in opposition to the government or otherwise Rwandan human rights activists as well. Now, and another thing that was kind of a major complaint or criticism of the Gachacha courts was that the government, which is currently led by the Rwandan People's Front, they excluded crimes committed by soldiers from the RPF from the jurisdiction of the Gachachas. So those who were victims of RPF crimes are still awaiting justice, or were at least at the time that the Gachachas closed. And I'd just like to close this slide quickly with a quote from the late Alison DeForge of Human Rights Watch, who said of the Gachacha program, "A system of reconciliation believes in recreating social harmony as the ultimate objective, and having people tell the truth, show remorse, is the best way to achieve that. But in a situation where the harm done goes far beyond the ordinary skill of what a reconciliation system is ordinarily meant to deal with, it's very difficult to find a way to include the element of some form of punitive action because the people who did these things should in fact be punished." Whoops, what am I having? Oh, no, back. Sorry. Okay, and now I'm going to speak briefly about transitional justice in the Gambia, which is something the Carter Center is working on now. So in the Gambia, they have basically, they have completed 2 phases of their transitional justice process, which are their Truth and Reconciliation and Reparations Commission, and a commission of inquiry into the financial activities of public bodies and enterprises and offices, which is really about the financial crimes. And sorry, to back up, sorry, I didn't give the introduction to the Gambia situation. So in the Gambia, there was a dictator in power from 1994 to 2017, Yahya Jammeh. He was removed from power in 2017 through a vote at the ballot box. He originally refused to give up his seat, to give up power, but after pressure from the Gambian people, he was ultimately pushed out of office. And now I'm realizing I don't have my notes. Apologies, I'm losing it. I'm very sorry. Excuse me one moment. Nick, Or Josh, could one of you try to share? I'm just realizing I don't have my notes for the next 2 slides in front of me, and I can't see them when I'm screen sharing.
Let me try here. I know we were having issues with this earlier today.
Yeah.
One
All right,
moment.
let me stop sharing and see what I can do. I apologize to everyone.
Hillary, I think it's fine for you to continue without the screen because we're coming to you know, a few minutes to save time for questions. So if you want to just you know, go ahead and finish with your notes, that's fine too.
Okay. All right, well, let me see. Okay, so in the Gambia, in response to the rather severe and gross violations of human rights that were committed during the Yahya Jammeh regime, the country, as part of its reconciliation and kind of national rebuilding after Jammeh was removed from office, they established the Truth, Reconciliation, and Reparations Commission, as well as this Commission of Inquiry into financial crimes committed by Jammeh and his associates. And then now, and then they also created a reparations trust fund with government funds to pay compensation to victims of Jammeh's regime. And then now we're moving into the accountability phase of their transitional justice process. And as part of this, the Gambia is working on establishing a special prosecutor's office, which would investigate and prosecute crimes involving gross violations of human rights committed during the Jammeh regime between 1994 and 2017, as well as a special criminal division within their high court to try cases domestically, particularly lower level offenses and crimes under domestic law. And then they have proposed to establish their own hybrid court along with the Economic Community of West African States, which would be an internationalized court which could try cases both in the Gambia as well as perhaps in other countries as is deemed necessary for political reasons and for security reasons. And so let me get to my next one. And so then I wanted to talk a little bit here about the Gambia's Truth, Reconciliation, and Reparations Commission. This was created created by statute by the Gambia's National Assembly in December of 2017. To create an impartial historical record of violations and abuses of human rights from July 1994 to January 2017, to establish and make known the fate or whereabouts of disappeared victims, to provide victims an opportunity to relate their own accounts of the violations and abuses they suffered, and to grant reparations to victims in appropriate cases. Between the start of the commission in January 2019 and its closure, its final public hearing in May of 2021, the commission heard from 392 witnesses, the majority of whom were victims of atrocities meted out to innocent civilians by the state, its agents, or individuals sponsored by both. And the witnesses appearing before the commission also included self-professed perpetrators. The commission itself had 11 members and who were appointed and by the president of the Republic of the Gambia. the TRRC published its final report on December 24th, 2021, documenting the human rights violations committed during the rule of exiled former President Yahya Jammeh. And in its report, the TRRC concluded that Jammeh and his associates committed crimes against humanity and called for their prosecution. Then in May 2022, the current government of the Gambia issued a white paper responding to the TRRC's recommendations, in which they agreed to the majority of the recommendations and promised to take steps to respond to those findings and recommendations, including accountability, taking steps to ensure accountability for those responsible for crimes against humanity and gross violations of human rights committed during that period of time. So now we get to my last slide, which I guess you all maybe can or cannot see, where we talk a little bit about our work here in the Gambia. So the Carter Center is currently part of a consortium of organizations led by Democracy International, under the rubric of a broader project consortium that we're a part of called JURIS, which stands for Justice, Rights, and Security. And under this rapid response project, the consortium, including the Carter Center, Democracy International, and the Gambia Bar Association, is supporting the Gambia Ministry of Justice to establish the Special Prosecutor's Office to investigate and prosecute crimes committed by the Jammeh regime and identified by the Truth, Reconciliation, and Reparations Commission. And through this, the Gambia Bar Association and DI are helping the MOJ to draft legislation and an implementation plan for the Special Prosecutor's Office to develop strategies for the socialization of the legislation across government and civil society, and to ensure linkages between the design and operations of the SPO with the ongoing planning for an eventual hybrid or internationalized court. And the Carter Center, as part of this, will provide training and coaching to the key stakeholders on approaches to increase citizen understanding of transitional justice and generate buy-in into the accountability process. And apologies for going over.
No. I mean, I think we're all sitting here with jaws dropped about everything that you all are doing everywhere, and so significantly to impact these countries and this transitional justice aspect that I think we all believe in. It's just amazing to hear your story. I'm so sorry we only did a 1 hour thing when you guys are doing so much, and I think many of us that are listening would love to do a part 2 of all this, so we can dig in deeper to some of the things, especially, you know, after Josh was explaining the community justice advisors. That's obviously what we all try to do as mediators, but you're doing it at an amazing level in impacting people directly. I've heard from Victoria that the slides that you all presented today would be available to the attendees if they would like it, as well as any follow-up questions that anyone has to learn more about the things that have been discussed today. And I guess if maybe Hillary or Victoria, if somebody could provide an email address for contact, then that would maybe be helpful to the attendees before we wrap up. Does anybody, I don't know if Victoria is still connected, but oh, there it is, victoria@cartercenter.org. It's in the chat, victoriaair@cartercenter.org. Please, if any of you who attended today, and I know we didn't save time for questions because there was so much information, if you have any follow-up or want the slides, please reach out to Victoria. She'll get them for you. And again, to the Carter Center and the 4 of you who participated, our deepest thanks for taking the time to teach us about these important issues that we all need to learn about. So thank you all very much for presenting, and thank you all of you for attending. I want to be respectful of your time, so we'll wrap up the program now. Thank you again.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining. Have a great afternoon.